Hello, my name is Casey Graul, and for my First Amendment research paper, I decided to do the case Johnson v. Poway Unified School District. Bradley Johnson is a San Diego high school math teacher who has worked in the Poway Unified School District for more than 30 years. For many years, he had hung various banners up in his classroom until recently when he was asked to take them down from his classroom walls. The phrases all were in relation to using words such as God, Creator, and since he's an employee of a public school, these signs can be viewed as inappropriate. The two banners in Johnson's classroom were said to be quite large. The first banner stated, "In God we trust, one nation under God, God bless America, and God shed his grace on thee." The second stated, "All men are equal, they are endowed by their Creator." One could see why these banners might be brought to a higher authority's attention. If a student of a different religion were to walk in the classroom and see these banners, they may begin to feel uncomfortable, and it shouldn't happen in a public school district. Johnson disagreed with this completely and refused to either remove his banners or display the more contextual versions the school offered to provide. He explained that he had displayed the banners in some form or another since 1982, that they simply contained patriotic phrases, and he considered it his right to have them up. He filed suit in federal court alleging that Poway had violated his rights under the First and 14th Amendments of the United States Constitution. Johnson was determined to prove that his banners were patriotic and nothing to do with the religion. He also believed he wasn't the only teacher in the district with banners that some may think to be inappropriate for the classrooms. He made a list and took pictures of multiple banners he saw hanging in teachers' rooms at all 4 high schools in the district. Some of these posters were things in relation to Gandhi, Dalai Lama, Malcolm X, John Lennon lyrics, and the Taliban prayer flags. A federal district court ruled in favor of Johnson in 2010, stating that the order to remove the banners constituted viewpoint discrimination because the school did not order other teachers to remove their religiously affiliated content. The case continues on September 13th when the U.S. Circuit Court of Appeals reversed the lower court's decision, relying on previous case to provide that when speaking as a public employee, government can limit one's free speech rights. What helped the court come to a verdict was they looked back on the Guisardi v. Celebos case. A brief explanation of this case is that Celebos was an employee of the Los Angeles County District Attorney, and he sues 2 fellow employees and Gil Guisardi, the district attorney, because he claims the 3 of them retaliated against him because he shared information with the defense counsel. Celebos believes all he did was exercise his First Amendment rights because he was informed that a sheriff might have lied and contained false statements in a search warrant affidavit. He shared this information with multiple people, and in the end, the defense counsel subpoenaed him to testify. The district court ruled that the district attorneys were protected by qualified immunity, but the Ninth Circuit reversed and ruled for Celebos, holding that qualified immunity was not available to the defendants because Celebos had engaged in speech that addressed matters of public concern and was thus protected by the First Amendment. Another example of a court case that defines when it is right for an employee to speak out as a citizen on a matter of public concern is the Pickering v. Board of Education. The high school teacher wrote a letter to the newspaper concerning the Board of Education's distribution of funds between academics and athletics. The school board was not pleased with the letter Pickering wrote, claiming the letter had false statement, and fired him. Pickering sued, saying the board violated his First Amendment rights. By an 8-1 vote written by the Justice Thurgood Marshall, the U.S. Supreme Court held that Pickering had a First Amendment right to free speech that could not be fortified because of the best interests of the school district. Justice Marshall also stated, "The problem in any case is to arrive at a balance between the interests of the public employee as a citizen in commenting upon matters of public concern and the interests of the state as an employer in prompting the efficiency of the public services it performs through its employees." So although Johnson truly believed that the banners in his classroom were not about religion but merely a symbol of patriotism and the roots of where our nation came from, other staff members and students would disagree with this. Who is to really say who is right or wrong and truly what the banners stand for? Would the banners be less of a deal if he taught another course such as social studies class? Should government restrict non-curricular related speech with the forum, meaning not only would they restrict teachers from having banners about gay rights or political candidates, but they would also restrict saying one nation under God? Another thing the court took into consideration was the Pickering test, meaning the posters that Johnson had in his classroom were those of public interest or were they more of something personal, meaning non-curricular related speech?